And this is part one of module 4, crimes against the person. We're going to talk about criminal homicide in this part of the lecture. Our sources for this presentation are our textbook, Criminal Law for Criminal Justice Professionals, and Louisiana Revised Statutes, Title 14, Articles 1 and following articles. So in this module, you'll learn to explain the difference between homicide and criminal homicide, define the concepts of voluntary manslaughter, involuntary manslaughter, second-degree murder, and first-degree murder, contrast the elements of the crimes of battery and assault, and define the crime of robbery and related degrees of the crime, and then finally identify the elements of the crime of rape and related degrees of the crime. So in terms of crimes against a person, homicide is the killing of one person by another. Criminal homicide, however, is any act that causes the death of another person with criminally culpable mens rea and without a lawful justification or excuse. In the early common law, there were two types of criminal homicide: murder and manslaughter. But there are three general categories that have evolved in the modern criminal law, which are murder, voluntary manslaughter, and involuntary manslaughter. Most states divide these further into grades or gradation of offenses. For example, Louisiana Revised Statutes 14, Article 29 lists the 5 grades of criminal homicide in Louisiana as first-degree murder, second-degree murder, manslaughter, negligent homicide, and vehicular homicide. The basic requirements for assessing criminal homicide liability are that a victim was alive at the time the act was committed, and the defendant's conduct must have caused the death. Of course, this raises legal questions about when does life begin and when does it end. In terms of fetal homicide, the born alive rule was prevalent in the common law. Within the common law, a person who killed a child born alive, meaning they weren't in utero or stillborn, could be criminally responsible. And some states continue to maintain the born alive rule. In some states, killing of an unborn fetus is considered a homicide under certain conditions, and that's defined as a crime of feticide. There are 4 types of fetal homicide depending on the stage of development. The viability stage means that the fetus is developed enough to survive outside the womb, which is about 5 to 6 months from conception. Quickening is this first movement of the fetus, or about 4 or 5 months from conception. And then the transition phase from embryo to fetus, which is about 7 to 8 weeks after conception, and then of course conception itself. Advances in medical science have led to some states to develop alternative legal definitions of the beginning of life related to criminal homicide. For example, Keeler versus Superior Court in California in 1970 revised its statutes to include that the purposeful killing of a fetus without consent of the mother is murder, and liability is for the entire fetal stage of pregnancy. Legal abortion is considered to be generally protected until the fetus is viable as a mother's right to privacy. There's some post-viability circumstances in some states, such as a medical emergency to protect the life of the mother. But on the other hand, abortion may be considered feticide in some states if it's performed after the fetus is viable and the mother's health is not in danger. Infanticide it brings into question whether the child was born alive during the act that caused the death. Medical evidence includes whether the child was born alive and physically separated from the womb, and whether the child had a heartbeat with independent breathing at the time of death. The common law definition of death is the permanent cessation of respiration and heartbeat. Again, advancements in science and medical technology has rendered this particular definition inadequate. It's been replaced by the concept of brain death, uh, in which permanent cessation of all brain functions, which absent any type of medical support would result in the body stopping all of its functions as well. Most states have adopted this Uniform Determination of Death Act, which states that an individual who has sustained either an irreversible cessation of circulatory or respiratory functions or irreversible cessation of all functions of the entire brain, including the brainstem, is considered dead. A determination of death must be made in accordance with accepted medical standards. In terms of a discussion about homicide and criminal homicide, that discussion has to include an individual's right to die. This is an expansion of individual rights to privacy and autonomy by the courts, which has led to legal, moral, and ethical questions about the right to die. Within the common law, suicide was a felony, punishable by forfeiture of the person's property. But under modern American law, suicide or even an attempted suicide is not a crime. In terms of right to die, most states have criminal statutes for assisted suicide, which is the act of aiding or abetting another to commit suicide. 6 states in the District of Columbia have death and dignity statutes, which protect the right to physician-assisted suicide. So the distinction has to be made between what's physician-assisted and what's euthanasia. Physician-assisted is where the physician goes about provision of the means for the person to end their own life, information on how to do it, or both, but not to administer the means of suicide. Euthanasia, on the other hand, is this painless ending of a patient's life that has a terminal or distressing disease, and euthanasia is brought out and conducted as an act of mercy. The elements of criminal homicide include that there be an act or omission of an act, in terms of the actus reus that we spoke about in previous modules. The act that produces death must be voluntary. An involuntary act can still be liable if conditions like fatigue or heavy intoxication exist, driving or operating dangerous equipment with some type of dangerous medical condition, or driving or operating heavy equipment under influence of psychoactive substances. Criminal liability also exists for failure to act or omission. And this omission is when a person has a legal duty to act on behalf of another person, but simply decides not to act. Another element of criminal homicide is causation. Causation exists when the victim is alive at the time of the act and the defendant caused the death. The common rules to address wide variations on the definition of death. We talked about that, some of those earlier, but under the common law, the year and a day rule existed. If a victim doesn't die between a year and a day of the injury, the defendant cannot be convicted. Some states still follow the year and a day rule. Others have adopted 3 years and a day statutes due to significant advancements in medical science and technology. Common rules to causation include the but-for test, and this means that without the defendant's actions, the victim would not be dead. Questions arise regarding events that occur after the defendant's conduct, but before the victim's death, which can contribute to the death or intervening acts. Courts have ruled that intervening acts continue criminal liability unless the act was totally unforeseeable, highly abnormal, completely independent of the defendant's actions or any combination. there's some use of a fairness analysis, or what's, the questions arise of, is it still fair to hold the defendant accountable for the death? Another test is the substantial factor test, and this is applied when two or more forces were sufficient to cause death and occur simultaneously, such as a drive-by shooting in which three shooters shoot the same victim. Causation does become an issue in certain omission cases, though. Another element of criminal homicide is that it be of another human being, or the corpus delicti of a crime. The corpus delicti is the body or substance of the crime. This requirement exists in every crime, but is especially important in criminal homicides. And there's two parts to it: that the defendant's statements or the confession alone cannot prove the crime has been committed. There has to be proof that the victim died as a result of the defendant's criminal act. Those must exist. A body, quote unquote, a body is not required, but the death can be proven circumstantially. Another element of criminal homicide is that the offender be criminally culpable, that they had mens rea. The determination of this mens rea is extremely critical in criminal homicide cases. It distinguishes murder from other forms of criminal homicide. But it's difficult to determine because determination is made after the act occurs, and the state of mind can only be established circumstantially through inferences, things like, was the defendant present at the scene? What was their conduct? Any statements or confessions made to others? And did they have motive? Under the model penal code, the mens rea element is that the defendant purposely, knowingly, recklessly, or negligently causes the death of another human being. And under the MPC, there are three categories of criminal homicide: murder, manslaughter, negligent homicide, and actually suicide has been added as well, when suicide is taken by force, duress, or through deception. Another element of criminal homicide is that it be without lawful justification or excuse. Justification is the killing of another under legally justified conditions, and then it's not criminal homicide. Remember, in Module 2, we focused on the behavior of the defendant and the victim. Excuses or legal defenses to a criminal homicide to show that there was this lack of moral culpability. And again, this was presented to you in Module 2 as a focus on the condition of the defendant. There are types and degrees of criminal homicide. The first, of course, being murder, in which all 5 elements of criminal homicide have to be proven. There's intent to kill. The killing when intent is to seriously injure the victim, even when no intent exists. The killing by reckless conduct or during commission of a felony, which means that there's implied malice in the act. Malice aforethought is this mens rea element in the common law of murder, in which 5 elements were present: the specific intent to kill another human being, which is express malice; the intent to inflict grievous bodily injury or harm upon another, which is implied malice; the intent to act in a manner that shows extreme reckless disregard for the value of a human life is implied malice as well; the intent to commit a felony that results in the death of another human being; and the intent to resist a known lawful arrest. Under the common law, the felony murder rule existed, and this was when a person was guilty of murder if he or she killed another, even accidentally, during the attempt or commission of a felony or while in flight from a felony. This is because simply within the common law, murders and felonies were punishable by death. Potential victims under the felony murder rule included the intended victim of the underlying felony, any innocent bystanders, law enforcement officials, non-law enforcement attempting to rescue a victim, and all co-felons in the act. The goal of the felony murder rule, of course, was deterrence. And in modern times, there's been limitations placed on the rule to mean that only inherently dangerous or forcible felonies could hold a person accountable under an instance of a criminal homicide. Things like degrees of burglary, arson, rape, robbery, kidnapping, forcible sodomy. In Louisiana, this includes degrees of escape, cruelty to juveniles, and of course, terrorism. Under criminal homicide and the type known as murder is this reckless disregard for human life. This means that the defendant's actions are so outrageous that the evidence of disregard for the well-being of others exists, even when they had no intent to kill. This is an ignorance of that substantial or unjustifiable risks that criminal harm could occur. For example, people are drag racing on public roads and a person dies, they can be charged with murder, or engaging in a game of Russian roulette. Degrees of criminal homicide, degrees of murder are based upon the level of the defendant's culpability, the severity of the act, and any other special circumstances. For example, first-degree murder, or what's known primarily as capital murder, is the intentional killing with premeditation and deliberation. This could be the unintentional killing even of one or more people by poison, torture, ambush, or use of a bomb, and could be the killing during the commission of an enumerated or inherently dangerous felony. Take a look at LRS 1430 and the Louisiana Revised Statutes for a definition of first-degree murder in Louisiana. Second-degree murder is committed with malice aforethought, whether it be express or implied malice, and does not constitute first-degree murder. This is usually this charge arises due to the lack of premeditation or deliberation. And you can check out LRS 1430.1 for Louisiana's definition of second-degree murder. Again, model penal code degrees of murder. It defines murder as the killing done purposely, knowingly, or with extreme recklessness, killing during perpetration of an enumerated felony constitutes murder as well. And then manslaughter is the killing done of another in a negligent manner. So take a look at Module 2 and review the justifications and excuses that can be applied to murder cases. Under another type and degree of criminal homicide is manslaughter. Voluntary manslaughter is the killing committed without malice aforethought, meaning there's a lack of mens rea for murder. And there are three particular circumstances that constitute manslaughter, even with the intent to kill or cause great bodily harm. The first is provocation, and this is when the defendant is under heat of passion or extreme emotional distress. The person acted in heat of passion caused by some legally sufficient provocation, or a person of reasonable ordinary temperament would lose control under the same circumstances. It's important that the accused must not have had time to cool before acting, that heat of passion had not reduced. Within the common law, the heat of passion was made very restrictive. It was specific to provocation circumstances and that were required. While modern law has tended to loosen those restrictions on heat of passion, in which specific provocation circumstances aren't required. For example, extreme emotional disturbance is a reasonable explanation for provocation. The second is mistaken justification, or this imperfect self-defense. When a citizen mistakenly uses deadly force, they can be held criminally liable for the death of a victim. In some states, there's no criminal liability if the defendant reasonably believed a felony was being committed. And then the third circumstance is diminished mental capacity. Was there extreme voluntary intoxication or some type of mental illness that doesn't rise to the level of insanity? Involuntary manslaughter is the unintentional killing while acting in a criminally negligent, meaning that the person is culpable or exhibiting gross negligence, or acting in a reckless manner where there's high and reasonable risk of death or great bodily harm. The conduct in this case must be so different from the norm that it shows indifference to the consequences. So this is the end of module 4, part 1. Please stand by for part 2.